what we've essentially done in organizing the seminar today is that we have decided to treat the employment relationship as a full seminar presentation today. So we're going to start at the idea of pre-hiring and selection of potential employees and move all the way to the issue of termination, separation from employment, and what may happen after that. I have the privilege this morning of speaking with one of our newest associates at McAfee Taft, Mr. Phil Bruce. He and I are going to discuss we're going to present on one of two pre-hiring sections that will be going on in our seminar this morning. We are staying with the 25-minute format, so Phil and I will present our discussion for 25 minutes, and then we'll immediately move into the second session. After the second session, we'll have a break, and then that's kind of how the process will work for the rest of this morning. Okay, so first, we're going to, as I mentioned, talk about some pre-hiring practices. The hot button issues in pre-employment in the world of labor and employment law. Of course, the pre-employment phase of an employment relationship, as far as the law is concerned, has an incountable number of issues. Okay? But what we want to focus on today is what are some of the landmines out there? What are some of the potential problems that we see employers facing that are related to the pre-hire process that may result in you ending up in court? What kind of cases are we trying right now? What kind of policies and procedures are we drafting right now that have to do with the selection of employees? So we're not necessarily talking about early stage employment, we're talking about before people are employed. And so we're going to talk about a number of things today, but we want to remind you that pre-employment practices, best practices, would include making sure you have job descriptions for each of your positions, making sure not just that you have them, but they are accurate. I cannot tell you how many times that I have had a piece of litigation come in, and one of the first things I ask is, do you have a job description for the plaintiff? You bet, we do. Here it is. Oh, but don't pay attention to anything on the first page or the second page or the third page because it's not really accurate. Okay, that's of no help to us. So one of the main things you have to do before you can hire a candidate is make sure you have a job description in place that actually describes what they do. And maybe more importantly than that, what the physical requirements may be, what the mental requirements may be for that position. I know that takes a great deal of time, but it is really, really important. Also, as a pre-employment issue that matters, you need to make sure you have those key policies and procedures in place that actually affect your selection of employees. So one of the most important would be a drug testing policy, perhaps a criminal background check policy or a credit check policy. All of those need to be in place before you can use those tools to select the employees that you want to hire. And so policies and procedures, obviously you're going to want to have a number of those that will affect the people that you ultimately hire. But before you can hire people, you're going to have specific policies, some of which, like the drug testing policy, that have to be specifically signed and acknowledged by the employees before you can engage in that drug testing. And as all of you know from listening to me speak for years now, I really, really encourage you to do that pre-employment drug testing. And so that's this one thing that you must have in place before you go. Perhaps the most important thing, and what we're going to spend most of our time talking about today, is employee pay and classification. It kind of follows the job description discussion, but you must really be giving thought to the proper classification of your employees and the proper mode of paying those employees that you're going to hire. And I see this a lot with small businesses where, in an effort to be creative, in an effort to be competitive in a tight market, we come up with creative ways to pay employees. And that's all fine, but we have to make sure that we are properly classifying those individuals and making sure that that doesn't result in an FLSA issue. And we have some very important FLSA issues, or perhaps not FLSA, but related pay issues that we're going to talk about today that should be on your horizon and things that you should be thinking about in evaluating your own pre-employment pay and classification issues. Obviously, you need to have a system in place to verify eligibility for work. This is another pre-employment system that you absolutely must have. We've talked about the I-9 process now for perhaps the last 3 or 4 years, that has been a very significant topic of regulatory authority, but it continues to be one. And so if you are not making sure that you're doing internal I-9 audits, if you are not training the employees that are responsible for your I-9s and making sure they really understand what those blanks mean and they really understand that they are important, I would encourage you to spend some time doing that. So my point is, in brainstorming for this, we just listed a very few things that might affect the pre-employment process. And now we're going to talk about, again, kind of trending issues that relate to these and other pre-employment topics. All right. So kind of the 4 main things we want to talk about a little bit today are the new minimum wage that was put in place by the executive order recently by the President of the United States. We're going to talk about some upcoming changes to the exemptions that the Department of Labor produces via regulation. We're going to talk about arbitration agreements, which, of course, as you all know, I advocate very highly for all of you. I could not be a bigger proponent of arbitration agreements for your employees. We're going to talk to you about how those affect the individuals that you're interviewing for pre-employment screening. And then we're going to talk about social media in pre-employment. We're going to talk about, and I'm sure some of you do this, I have done it in the past, but we're going to talk about whether or not it is appropriate or lawful to use social media as a screening tool. And those are going to be the 4 key topics that we talk about today. All right. So the first point is a new minimum wage for government contractors. Now, some of you in the room, I know, because I work with you, are government contractors, and this is going to be particularly important for you. Others of you are not government contractors, or you think you are not a government contractor, and you really are, and we're going to talk about that. And then others of you just may become government contractors in the future. So this becomes an important topic for a lot of you to think about in your own pre-hiring discussions. All right, so Executive Order 13658 was published by the President of the United States very recently. It affected the minimum wage for entities that engage in new contracts or contract-like instruments, whatever that means. But there are Department of Labor regulations that define what contract-like instruments are. And the Secretary of Labor, the Department of Labor, will be publishing regulations that make this particular executive order a little bit more clear, and that will be coming in the fall of this year. Like all regulations, there'll be an opportunity for public comment on the proposed regulations. We very often help our clients with preparing public comment to proposed regulations by administrative agencies. So if you read those proposed rules and you have some comments and want to publicly comment on that, please let us know. We'd be happy to help you with that. But that process is going to be flowing out over the next several months, and it will be interesting to see how active the Department of Labor wants to be in spreading the impact of this executive order. I suspect you will find, based on how the Department of Labor has acted for the last 5-6 years, that they will attempt to interpret this executive order as broadly as possible. And so that's why I want this to be on your radar screen as we go forward. Again, that executive order is not yet effective, but it will go in effect in January 1st, 2015. It will raise the minimum wage from $7.25 an hour to $10.10 an hour. And it was very interesting when I read the executive order the first time. The introductory paragraph uses some very glowing language about why it's necessary to raise the minimum wage from $7.25 an hour to $10.10 an hour. And every single one of those reasons was to save you money. I was puzzled by that. Politics aside, and whether or not an increase in the minimum wage is a good thing or a bad thing, that's all debatable, and probably there's good arguments on either side. But I was just surprised at the reasoning that was published for it. The government is here to help you, ladies and gentlemen. Okay, after January 1st of 2016, the minimum wage, again, for contractors, will continue to increase. It will continue to increase. So $10.10 an hour is not the final number. That's just where we're going to start in 2015. And interestingly enough, one of the most comprehensive changes, and some of you I know are in the food and beverage industry, is that there's going to be a massive change to how tipped employees are paid. As a guy who has waited tables many years ago now, this is an interesting change to me, and it will be a significant change in how your employees are comped if they are tipped employees. Major change. It is possible, though, that the minimum wage will still be below the prevailing wage. If you are a federal contractor and you know what that means, you may have an obligation, and likely do have an obligation, to pay a prevailing wage through your federal contracts. In that case, if the prevailing wage is higher than the minimum wage, you're still going to have to go with the prevailing wage. So pay attention to that. That does not change. All right, now, as the kind of first indication as to how broad the government intends to expand this coverage, we've seen some regulatory agencies already publish some discussion about who is covered by this executive order. All right, for example, there was a letter recently published by the FTC that illustrated what it thinks the application of this executive order is to the banking industry. Okay? And what's interesting about that is banks don't typically have what we would consider a federal contract. They don't have a contract with the government to provide some service for the government on behalf of the government, like you would normally think of a federal contract being. But the FTC is taking the position that banks are federal contractors, and therefore this minimum wage change is going to apply to them. Now, whether or not that ultimately turns out to be the case depends a lot on the regulations the Department of Labor publishes this fall. But it was very eye-opening to me when I read that bulletin, because it seems very clear that there's going to be an expansive approach taken to who is a federal contractor and who is not. Okay, so if I were running the Human Resources Department for an employer right now, I'd be paying careful attention to these bulletins describing what the government thinks a federal contractor is for the purposes of this minimum wage change. May also apply to universities and hospitals, the aerospace industry, the oil and gas industry. There has been some talk. I know we have a number of oil and gas clients that have already asked about this. But there has been some discussion by some government agencies about the fact that if there's drilling being done on any land that has any relationship whatsoever to the United States government, that is at least currently being debated, whether or not that drilling qualifies you as a federal contractor for the purposes of this minimum wage. So again, something to pay careful attention to in the future. Okay? Because this is an executive order, that means it is not a part of the FLSA. So this particular minimum wage rule is not enforceable by a private right of action, by a lawsuit, but it is enforceable solely by the Department of Labor. Okay, now, if Congress acts and changes the minimum wage itself, then of course it would certainly become lawsuit material, just like any other minimum wage claim is now. All right. Next thing that I want to point out, kind of the second main topic, is the idea of not an executive order, but a presidential memorandum that was issued recently by President Obama directing the Department of Labor to rewrite the regulations that define some of the exemptions to the Fair Labor Standards Act. Essentially what he has done is told the Department of Labor that he wants the regulations rewritten to broaden the coverage of the overtime pay rules. And this time, and that happens periodically and has over the last several years, but this time the target is administrative and executive professionals who may normally qualify as an exempt employee based on their supervisory duties. The point here now, and of course, let me back up one more point. Not just the duties test, right, but also the salary basis test and a minimum of $455 a week. That's how we go through the exemption study for individuals that may be exempt because they supervise employees. The issue now is the president wants that reevaluated. What should the minimum salary be, minimum weekly salary be, in order to qualify someone as exempt? That is the most likely change that is going to fall out of this. We're going to have a much higher minimum threshold before someone can be exempt. Okay? It is likely that these regulations will also come out this fall, but it's again something that I would be paying careful attention to, and it'll be something that as those regulations come out, we're going to need to think about what impact those regulations have on our existing exemption classifications. All right. At this point, I'm going to stop and I'm going to hand the podium over to Phil Bruce, and he's going to talk to you about social media and arbitration agreements. Thanks.
Thanks, Paul. As Paul mentioned, we have recommended that you have an arbitration agreement with your employees and with your applicants for some time now. If you're not familiar with what binding arbitration is, it's essentially a private lawsuit with your own private judge that's on your payroll. It's also on the other party's payroll too, because there's usually a fair sharing agreement for the arbitrator where you come to an agreement on who the arbitrator is, which will usually be an attorney or a retired judge or an expert in the law, and you usually pay their hourly rate. And we've recommended arbitration agreements with employees for a lot of reasons, but two of the main ones are, one, it's more predictable. As you take the case out of the jury's hands, so you don't have 12 unknown people there that are making the decision for you. You have one person that you've gone through the process of helping select, make the decision of what will bind both you and the other party. Second, it can save a lot of time and money. These cases are usually fast-tracked, there's limited discovery, and even if you lose at arbitration, that reward will likely be less than if you were in front of a jury that made a decision on an emotional basis. But the third reason that we're going to talk about and focus on today is the hot button issue, that is, it is now clear that employers can mandate employees waive class action and collective FLSA, Fair Labor Standards Act, actions based on a couple recent Supreme Court cases and some circuit court cases. Last June, the Supreme Court in two cases, not one, two, actually upheld a class action waiver in arbitration agreements. And one case in particular was American Express versus Italian Colors Restaurant. And the Supreme Court upheld this agreement despite the possible plaintiffs' individual recoveries being less than the actual cost of the arbitration, that it was economically unfeasible to arbitrate on an individual basis, and the Supreme Court said, that's fine, you can still make them go to arbitration. Now, neither of those cases were in the employment law context, but there's now been at least 5 federal circuit court cases that have said this applies to FLSA collective actions and other employment laws. Most recently, the 11th Circuit last month said this applies to FLSA collective actions. So basically what we know now is you can have an applicant fill out an arbitration agreement. They have to sign it. It cannot be part of your employee handbook. It has to be a standalone document, and they waive the right to any sort of class action or collective action against your company. And that is important. One of the biggest risks facing employers today is the FLSA collective action. These cases can be in the millions of dollars, and it's because you can aggregate small claims. For instance, you may have a worker that you owe $1,000 in overtime, back overtime wages to. Well, if a plaintiff can group up 1,000 of those employees that you failed to pay $1,000 to each, you've now got $1 million case on your hands. But with arbitration, they have to handle those cases individually, and a plaintiff's attorney cannot group them together. And these have been popular with plaintiff's attorneys. When they have a client come in the door saying, I think there's other guys like me or women like me that haven't been paid overtime, they start salivating because they can get millions of dollars from these fees because they can pool them together. So with the holding in Italian Colors, and the supporting circuit case decisions, employees can now require all of these employees to say, no, I have to handle this on an individual basis. And that takes out the incentive for plaintiffs' attorneys to group these people together. They can't send out a notice to your company saying, hey, there might be overtime violations, and they have to find them individually. And also because of the Talon Colors case, where the court said it's okay if it's economically infeasible, then there's no incentive for a lot of plaintiffs to do this. If they only are going to get $500 in overtime, but it costs $2,000 to pay the arbitrator's hourly rate through the course of the arbitration, common sense just says they're not going to go ahead and do that. But because I'm an attorney, I cannot make a recommendation without at least one caveat, and that is there's still an unsettled area here with the National Labor Relations Board, the NLRB, has said that these arbitration agreements that waive class action, collective actions, violate the National Labor Relations Act because they will prohibit concerted activity, which is being able to discuss the terms and conditions of the job with other employees, talking about salary and how your boss treats you, and being able to unionize. Now, the good thing is the Ninth Circuit has hinted that they think that's a losing argument. And the Fifth Circuit, which is Texas, Louisiana, and Mississippi, has already said that the NLRB is wrong on that. Now, the court is seeing if they're going to rehear that case. There was a motion by the NLRB to have the court sit en banc, which means the entire circuit will listen to the arguments and make a decision. So we're still waiting on that decision. But right now, it looks good for employers to be confident that these agreements do not violate the NLRA. So in the meantime, we still encourage you to have an arbitration agreement and include clear language in it that will waive collective actions and class actions. And unless there's something unique about your business or your industry, you should take a serious look at that. And this is especially true because of what Paul had just talked about with the recent changes or the upcoming changes to the DOL regs. Because there's going to be uncertainty in the law for a while after these are changed, how courts will interpret these changes. And if you get the law wrong, at least you can protect yourself by being in a more predictable form rather than in front of some juries that may be more sympathetic with the plaintiff. Our last hot button topic we're going to talk about is social media and pre-employment. This can be logging onto Facebook and looking at an applicant's page. It can be looking at their Twitter posts, if they have a blog, going through their Instagram photos and seeing pictures of their family to get a better feel of how this person will work in the workplace. And there are some developing issues, primarily with requiring access to an applicant or an employee's social media, or even requesting access to applicants' social media pages. One of these issues is with the EEOC. The thing you need to know about social media with applicants and the EEOC is that this can bring up a discrimination case. That's because you'll be exposed, if you're the one making the decision and you're the one that hops on Facebook and tries to look at the applicant's page, you may be exposed to impermissible information. Now, none of you would hopefully not ask for a picture as part of your application because you would see information about the candidate, their race, possibly their age, and that would be impermissible information, and you don't want to even bring that into the decision-making process. But it's worse if you get onto an applicant's Facebook page, because you're going to see their race. There's probably going to be pictures or selfies of the person taking pictures of themselves and their family and friends. You'll see their posts. You'll see them talking possibly about their religion, their politics, and it's much worse than just asking for a simple picture. As a personal example, my wife and I, we just had the most adorable little boy 5 months ago. Now, if you're not on Facebook, there's three things you can't avoid. If you don't know this, you can't avoid political rants, pictures of babies, and personal milestone announcements, like announcing the birth of a child or that you're expecting. Well, I definitely post a lot of pictures of my baby. He's adorable. I have to do that. And we also announced that my wife was expecting on Facebook. Now, let's say she was applying for a job and had an interview, and it went great. She was smart as a whip. She was engaging. She was personable. She was funny, which are all true things, and please tell her I said that. And she comes home and says, I think it went great. I'm probably going to get this job. Well, the hiring manager says, this is great, we're going to have to hire her, and then he hops on her Facebook account and sees that she just announced that she's expecting a child. Well, uh, that might factor into his decision-making process, thinking, well, we're swamped right now. We don't want to take the risk of her being out on maternity leave, or worse, we don't want to take the risk of her not coming back after maternity leave and being back in the same position we are. So that's, if you have a plaintiff's attorney that got wind of that, you would have a problem on your hands with a gender discrimination claim because you were exposed to that impermissible information. That said, social media does have a place. You can learn and maybe corroborate some information about education. You can see if they've badmouthed employers, maybe if they've shared some confidential information in the past. But if you're going to do that, and I think Kathy and Sharolyn are going to talk about this a little bit too, try to insulate yourself. Have a third party do the social media background check so you don't see the information that you shouldn't be relying on. The other developing topic is Oklahoma House Bill 2372. This bill would make it illegal for employers to request, which is just asking for, or requiring as part of a condition of employment to see the social media web pages or access to an applicant or an employee's social media accounts. What this bill would not do is make it illegal or prohibit employers from viewing this information if it's publicly available. There are still a lot of people out there that don't know how to work Facebook privacy settings, and everybody can look at what they're posting. And in fact, even if you do have privacy settings, it's the internet, it's going to be out there forever, and a lot of people don't recognize that even if they say only friends can see my posts. Procedurally in courts, what this bill would do if it became law is give employees and applicants a right to a lawsuit, to sue the employer, which is bad news. The one thing you don't want is to worry about one more possible lawsuit. The good news is that the most recent version of this bill would limit it to $500 in damages per occasion and also possibly allow injunctive relief, which would mean that the employer just has to stop requesting or requiring access to social media. And also there's a short statute of limitations in the most recent bill, which is a 6-month statute of limitations, meaning an employer applicant would have to sue within 6 months of that illegal request. Right now, the bill has unanimously passed the House, and it's passed out of committee, and it's got its second reading in the Senate, which means it'll likely go to the floor. We anticipate that this will pass and become law pretty soon, but with Oklahoma politics, you never know what's going to be traded, and there'll be horse dealing, and so it's possible it won't. So you should keep this on your radar and see if this changes or if it becomes law. The other thing you need to be aware of is this is a nationwide trend. There's at least 9 states that have already passed similar laws, and a couple of days ago, actually, there was a bill that was sent to the Wisconsin governor's office for his signature to turn it into law. So if you operate in Texas or Arkansas, or maybe even any of the 26 other states that are considering similar bills right now, then you should be aware that it may already be illegal or soon to be illegal in other states as well if you have operations elsewhere. So what's the takeaway? The takeaway is if you have a policy or a practice right now where you hop on to Facebook, Twitter, Instagram to look at a applicant's social media, first you should try to insulate yourself. Second, you should know that requesting that access is probably going to be illegal pretty soon, and you should either stop that policy or start backing away from it now. And if you operate elsewhere where it's already illegal, you should definitely stop the practice right now. Back to Paul.
Great job, Mr. Bruce. Thank you so much. And that email where I asked you for access to your Facebook page, never mind. I apologize. Okay, that pretty much wraps it up for us in the first session. At this point now, we're going to transition, as I said, right into our second session. And I'm going to introduce to you Kathy Neal and Sharolyn Whiting-Ralston from our Tulsa office. And they're going to discuss some more common pre-employment pitfalls for you to keep in mind. Thank you very much.
Further and talk more about some missteps that you can make in the pre-employment hiring process. I'm going to talk a little bit about may know, you may very well be aware of this, but federal law, they're waiting at me. What you cannot do is discriminate once you know what the applicant's criminal history is. And there are two ways that you can do that. One is by actually treating people with criminal histories differently because of their protected characteristics. The other way is that your questions and your investigation into that criminal history has the effect of discriminating against people with certain protected characteristics. And the EEOC is concerned with both types of discrimination, but has issued us some guidance on when the disparate impact, the use of a practice of investigating criminal history has the effect of discrimination. Now, its guidance was issued in 2012. It's not the law, but it is an insight into what the EEOC may be seeking or looking at when it investigates you, and it may very well be entitled to some deference by courts when you're at trial. So the EEOC basically says you cannot implement policies or practices that significantly disadvantage certain races or people and which do not help you in deciding whether or not the person is going to be a responsible and good employee. You can, if you do find that you have an adverse impact by using a criminal history investigation, you can avoid liability if you can show that your inquiry was job-related and consistent with business necessity. So what does that mean? Well, you look at whether or not the nature and gravity of the offense or the conduct has some sort of a relationship to the nature of the job that the person is seeking or is holding. And you look and determine whether or not time has passed since the offense or conduct and or completion of the sentence. And if those things taken together make sense, then you may very well have shown that it's job-related and consistent with business necessity. For example, if I am interviewing applicants for a CFO position, it may very well make sense that I screen out somebody who has a conviction for embezzlement. I mean, that's a no-brainer. If I am looking for someone to perform some sort of a clerical position, and I see that he or she has a DWI from college 20 years ago, person's not going to be driving one of my vehicles, that very well may not have any kind of relationship or business necessity connection. So the EEOC is saying, we're going to look at this, but we're going to determine whether or not it's consistent with your business and whether or not it's necessary. And the EEOC is very concerned about arrests versus convictions. Why is that? Well, according to the EEOC, statistical evidence shows that certain races continue to be wrongfully arrested and or convicted at a higher rate than others. So remember, when you're doing the investigation into criminal history, that an arrest is not the same as a conviction. Arrests not necessarily mean that someone actually committed the crime. There's a difference between that and a conviction. And also, even though federal law does not prohibit asking about someone's criminal history, states may. There are a number of states that do prohibit or limit your ability to make that investigation or ask those questions. Oklahoma allows you to ask both about arrests and convictions, but other states clearly do not. Can you?
Not only will not let you ask about arrests and or convictions, but they may have just limits within that. For instance, California will not allow you to ask about a conviction for a marijuana-related offense that is over 3 years old. And so they have some real distinct, unique things in various states. So please, whenever you're going to conduct those sorts of things or ask those sorts of questions, that you're making sure that you're complying with your specific state law that you're in.
So what are your best practices? How do you mitigate any kind of risk that may be present when you do make these investigations into criminal history? Well, first of all, advise them. Give them notice that you are going to conduct a criminal history background check.
and make them sign off on a written document giving you consent to do that. I've seen that be embedded in an application. I think the better thing is to make that part of the hiring packet that you give them. It's a separate sheet of paper. They're clearly notified. They clearly agree. And advise them that they are not required to reveal arrests or convictions that have been expunged. And that is the law in Oklahoma. It may very well be the law in other states that you're doing business. When you do this, develop a plan. Think about what are your goals? Are you concerned about theft? Or are you simply worried about excessive absenteeisms and tardies? And figure out how does my investigation into the criminal history meet this goal, if at all? And don't just allow your supervisors or your managers or anyone to sort of do this on an ad hoc basis. Make sure you've got someone or persons designated to actually conduct the check. Look at, when you're doing screening, make sure that it's not an automatic bar, but consider, again, the nature of the crime, how much time has elapsed, the relationship of the crime to the job, and this should be an individualized assessment for the applicant, not something that you automatically apply across the board. It would be very helpful, I think, to make it a multi-level decision. Have more than one person involved in the process of reviewing the decision. And then, of course, as you know, you've got to keep records on why you made that decision, what you found during the criminal history search, and the reason for your decision. Sharolyn's going to talk about the Fair Credit Reporting Act.
I'm going to dovetail a little bit on what Kathy was just talking about. If you look at the EEOC guidance on using background check information, the list that she just went through on developing a plan and who conducts the checks and what sort of information is used, why you use it, the EEOC actually recommends that you have a written plan put in place, somewhere in your documentation. It's not a bad idea, right? Because then if somebody comes back later and says that you have somehow improperly used background information, you've got a document that says, hey, this is the process we go through, this is why we're asking those questions, and it's why we're using the information. So you're a step ahead if you actually have a written document, a policy of some sort, within your arsenal to use. So, like Kathy said, I'm going to talk a little bit about the Fair Credit Reporting Act. And I'm going to apologize because we've got a lot of information on these next few slides, but the reason we put the information in there is not because we're going to talk about each bullet point, but because this is the specific information that you're going to find on the website of the requirements, okay? So we wanted to give it to you in sort of a document so you could take it with you. But the Fair Credit Reporting Act is going to apply whenever you use a third party to do your background checks. Okay, so if you just do your own background checks, you get online, you check anything that's publicly available, you do it all in-house, that's not going to be a consumer report typically for purposes of the FCRA. Okay, but if you're using a third party to do those, you probably are getting a consumer report, and you need to make sure that you're complying with these various steps. And this is now being enforced by the Consumer Financial Protection Bureau, and again, it's a 4-step process, and we're going to talk about it. First one. What you have to do as an employer, if you're going to hire a third party to do background checks for you or credit checks for you, is you have to make all these certifications, okay? You actually have to sign in your contract these various things that are bullet point listed here. Basically what you're saying is, we won't violate the law. We'll do exactly what we're supposed to under the Fair Credit Reporting Act with respect to notice, with respect to consent, with respect to how we use the information, and with respect to what we do later on when we notify the potential employee if they're not getting the job based on something that you found in that. So again, you use it for employment purposes only. That's what's called a permissible purpose. And again, you can look at these various things. I'm not going to go through each one of them, but these are here for you to take away with you. But basically, you're saying we're going to comply with the law in this area. So this is the second step. This is the really important piece. Kathy just talked about asking or getting consent from employees for a background check. Always recommended if you're doing it in-house, absolutely required if you're getting a consumer report. It's required under the law. You have to give them notice, and you have to get a signature. And the FCRA actually requires that to be on a separate document. Okay, now you can have the notice and the consent together, but it can't be part of the bigger application. So that actually needs to be a separate document. The whole idea is to make sure that the applicant understands what you're going to be doing, that you're going to go look at their background and possibly use that information to make a decision. And note that under Oklahoma law, you need to provide a little box that allows the applicant to tell you right away whether or not they want a copy of that report for free. Now, there's another thing, in addition to the consumer report, there's this investigative consumer report. Okay, so this is a report that goes a little bit deeper, if you will. This is a report where the third party may be going out and making phone calls, calling relatives, calling that apartment complex where somebody lived, getting information about somebody's personal reputation, those sorts of things. So it's a little bit deeper. If you are getting an investigative consumer report, then you have to tell the employee, and you need to or the potential employee, and you need to let them know within 3 days of requesting that report. You also need to provide them at that time a summary of your rights under the Fair Credit Reporting Act. That document is available online. All you got to do is Google it. You can find several copies of it. I recommend you have some on file if you're doing any of this sort of work. So once you go, you get, let's say you just get your consumer report, and now you've got to make a decision, okay? If you decide not to hire someone based on something you've found inside a consumer report, then you need to let them know, first of all, before you make the decision, okay? This is key. Tell them, you know, we found this out, provide them a copy of that consumer report, and provide them a copy of that summary of their rights, and let them know that you're getting ready to make an adverse decision based on something you found in that report. Then, give them a reasonable amount of time to come back to you and say, hey, that John Smith that you found that information about, that was not me. Or, you know, it gives them the opportunity to, you know, dispute something that, you know, lots of us have had credit agencies get things wrong. It gives them a chance to let you know that what you found out was not them, or it was somehow taken care of, it was a mistake, it was supposed to have been taken off, etc. What's a reasonable amount of time? 5 days, you know, 10 days, something along those lines, but give them time to tell you why you shouldn't make that decision, and then you can make that decision after that time. If you do, in fact, make the decision not to hire them based on the information that you found in that consumer credit report, you need to give them a notice of adverse action. And that notice needs to include these various things. Importantly, the name, the address, and the phone number of the credit reporting agency that supplied the information. The fact that the credit reporting agency or the consumer reporting agency is not the one that made the decision, but rather you're the one who made the decision as the employer. And let them know that they have a right to go and talk to that agency and dispute the information that was in there. So again, pretty basic notice, but you do have to provide them that notice if you've made that decision based on something in that report. So they touched on it a little bit earlier. We're going to move on to a little bit more about using social media and hiring and some of your best practices. So some of the concerns that we always see are, you know, you get, like we were talking about earlier, you get all this information out there. You get private information, you can possibly get private information, you get publicly held information. As long as you access and use only publicly available information, you know, you should be fine, okay? Again, you're not going to ask anybody for their passwords or anything like that. But if you can Google it, you know, it's fair game. And we all have that information out there that, you know, from your, you know, high school yearbook, it's how fast you, you know, ran something or something like that. That information can be found on anybody. If it's publicly available, it's fair game. However, we really, really do recommend that you have a process if you're going to do that. Be consistent in the way that you're going to use social media in your hiring. This is a place, again, where I recommend that you have an actual written plan in place, okay? Think about why you're using it. What are your goals in using that social media? Are you going to use it for all of your candidates? Are you just going to use it for a certain group of candidates, and why would you choose those people? What's going to be the scope of the search? Are you just going to Google and then look at everything that's on there? Are you going to, you know, type somebody's name into Facebook? Are you, you know, how are you going to limit, or how are you going to expand your search? And you want to think about those things with respect to what sort of information you really, really do need for a business reason, to make a business decision about hiring this person. The other thing is, be careful about who conducts these things. They recommended earlier that you get a third party to do that. I think that is not a bad idea at all because it limits the number of people. But the reality of it is, and we all know this, that supervisors go out there all the time, or potential supervisors who happen to be part of the interview process, they go home and they Google somebody, right? And they get all that information. You need to be very clear that you're going to have, if it's going to be done in-house, any sort of social media investigation needs to be kept to maybe 1 or 2 people within the organization that know the policy, they know how it's going to be applied, and they're going to use it appropriately. You don't want this freelancing going on. Again, it opens you up to all sorts of problems. You get information you don't want and you don't need. Okay? And Kathy's going to finish out the presentation here.
Okay, so let's talk a little bit about the interview. It is where a lot of employers trip up. And there are a couple reasons for that. One is that usually the person who is conducting the interview is the supervisor, and that person logically wants to see who he or she may be hiring, yet they may not be trained to conduct an interview in the appropriate manner. So the lack of training and the fact that many interviews are just painful. And you tend to try to fill the gap, or you want to make the applicant feel comfortable, so you tend to get a little casual. And I think sometimes that casualness may lead to an unintentional stray remark. The stray remark sometimes comes back to bite you in an EEOC charge or a piece of litigation. So the interview is, again, a crucial part of your hiring process. So what are some tips for how that interview is handled appropriately? Well, one of the best things you can do is use the job description. Again, it needs to be an updated current job description because it does you no good if you're using an outdated job description to interview somebody. But you ask questions that are related to the applicant's qualifications, the applicant's abilities to perform the functions set forth in the job description. I think a good idea is to interview in teams, and maybe you pair that supervisor up with somebody from HR. But one person can take notes, the other person can ask the questions, or it can be, 2 people asking the questions, but you've got a witness to what was said and what wasn't said, and you've got someone who's actually making that record for you. And you don't just walk into an interview completely unplanned, right? That's a good scenario for someone to make some mistakes. So, plan out what you're going to say. Have a list of questions that are open-ended, designed to elicit information, and they're the same questions for each candidate. Don't switch the questions around because that's kind of setting yourself up for a claim of discrimination if somehow the questions are different for someone of a different race or someone who's female versus male. And think about when you're going to time that interview. Are you going to do the interview at the very beginning, and then you're going to do the references, you're going to check the criminal history, you're going to do your credit history or the investigative report, or are you going to do all that check and then conduct the interview? I think that depends on what kind of business you have and how comfortable you feel with the process. Be careful about questions that are disguised. And maybe another way of saying that is a question that's kind of unintentional, but leads to information that you shouldn't consider. It could be as innocuous as, tell me about your family. Well, or, what have you done for the last 4 or 5 years? Well, all of a sudden you've got perhaps a female applicant who says, well, I've been at home taking care of my kids, or, I have 2 young children, then that person's not selected, and then someone may allege that in the interviewing process you discriminate against them because you elicited information that you shouldn't have considered. And one of the troublesome thing that comes up in an interview is sometimes you get information that you just didn't ask for. And, do you use it? Do you disregard it? How do you handle that unsolicited information? What do you like to, tell us a little bit about yourself. What do you like to do? Well, I'm the grand poobah of the local KKK. Okay, so, and people tell you the strangest things sometimes in those interviews. So if it's unsolicited, it's out there, it's done. I think a good way to handle that would make sure that on your employee notes, or the notes from the interview, you say, applicant volunteered that she does blah, 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 blah. But if it's impermissible information, to the best of you can, you need to disregard that information in making the employment decision. That is a troublesome area, no question. So now we're into the selection process. And what are best practices for this? A multiple participant program, I think, is very helpful. So you've got the supervisor, you may have the supervisor's manager, you have somebody from HR. Everybody has some input in the selection process. Make sure that you gather all the information up and you consider all the information that you gathered. And it does you no good to go check references or look at the criminal history if that information is not in front of you when you're actually making the selection decision. Again, document it. Document why you think applicant A is more qualified than applicant B. And then I think it's very helpful to have a consensus decision so that when someone challenges the decision, you're able to say, look, it wasn't the 26-year-old who chose not to hire the 57-year-old. It was a group of people who believed that the 57-year-old lacked the requisite qualifications, and that group is someone who's 26, someone who's 62. So you give yourself, it diffuses, and you give yourself a little bit better of a defense.
I think if I might add too, on the consensus decision making too, if you've got supervisors who are going to be working with that person, they're the ones who know on a daily basis really what that person's going to be doing, right? And so as the HR manager, you may not really know all the gory details of the daily grind. And so you making that decision along with a supervisor perhaps, again, helps you possibly get a better person in that job.
Agreed. Okay, so you've selected the candidate, and then you need to make some sort of an offer to them. Maybe this candidate is someone that you feel like you need to have a written employment agreement with, which is a different animal than giving someone an offer letter. You need to be careful how you craft the offer letters, because I've had several lawsuits where someone said, in one of them, a guy said, you offered me employment for a lifetime because you said that I would be a permanent employee. Well, the court said, no, that's not the case, but it was a lawsuit. It got to litigation. So that offer letter ought to have the job duties and responsibilities, at least a summary of what this person's going to be doing. You should set out, bullet points of what the compensation and benefits would be. And of course, who they're going to report to, what department they're going to be in, and information that kind of gives them an idea of exactly what they're going to be doing. But the very important thing is, of course, to make sure that you disclaim that offer letter is not a contract, that they are employed at will, and that either you or they are free to terminate their employment at any time for any reason. Thank you.